Thank you. Good afternoon. Yeah. So, well, I started by our regulation. Sorry. Just to give you some ideas of the opposition procedure. So, as you know, once our trademark is published, the application, we open a window of 3 months for receiving opposition. So, for us, it's a pre-registration procedure, and it is not ex officio. So from what I understood yesterday, this is one difference already with your practice in the Philippines. So you perform the relative grounds check before the registration by the office, right? Yeah. So it is upon request, and due to one of the Article 95 from the European Union Trademark Regulation, we are limited, the examiners, to the facts, the evidence, and the arguments submitted by the parties. It is an inter partes procedure, so any communication that comes to the office, we exchange between them, and the opposition should always be in one of the 5 languages of the office. This Germany, English, Spanish, French, or Italian. So as I mentioned in the timeline, there is where the opposition will take place in case a third party and the opponent submits the opposition. So I listed here the relative grounds of refusal, and I will focus on the double identity and likelihood of confusion. And later on the marks with reputation. Just briefly mention Article 8.6 that Monica also had in her presentation. Just the difference is because the difference between trademarks and geographical indications is that the geographical indications focus on informing the consumer of the origin of the goods, of the region, and the special qualities associated to that location, whereas it is not protecting the origin of the goods in terms of the company who is behind, not the commercial origin. And that is the difference when applying the Article 8.6. So with a limitation in the goods and services in the class, like, for example, Monica explained of champagne with a geographical indication, then the opposition will be sorted out. With the trademark application will be registered. So for the double identity and likelihood of confusion, here is our article of the regulation. And one of the important things is what is considered as an earlier mark. The trademark with a date of application which is earlier of the date of the application of the contested mark, and where appropriate when it is existent the priorities, application for such marks subject to registration, and the well-known marks under Article 6b of the Paris Convention. So the Article 8.1a, it requires identity between the goods and services and the signs. So this is what we call the absolute protection. We don't need to demonstrate then the likelihood of confusion if both the goods and services and the signs are identical, which means that we do not enter into considering the likelihood of confusion on the public. Okay. So, for example, I really like the logo of the Jollibee. So I use it in the presentation. We have identical signs, identical goods. So then if I put the hat of the opposition decision examiner, I will go through the double identity 8.1a. Here in this case, even though the signs are identical, goods are different, clothing versus hamburgers. So then this similar, and we will refuse based on Article 8.1b. We have a recent case law from 2023 of the hacker space that refers to the possibility on the past, our practice was that if the opposition was based only in Article 8.1a and the goods and or services were not identical or the signs either, we pass through 8.1b. So maybe the opposition was refused because they were not identical based on 8.1a, but in the Article B, we can uphold the opposition. But since this sentence from the General Court, our practice changed, and now we cannot do it only if the opponent also claims the Article 8.1b. Okay, this was just to mention this change of practice from EUIPO. So, because of the identity with or similarity between the mark and the identity or similarity of the goods and services, the Article 8.1b also covers the existence of likelihood of confusion. Then we take into account for assessing the likelihood of confusion, the comparison of the goods and services, the relevant public and the degree of attention, as I mentioned before. Then we compare the signs and the distinctiveness of the LMAC. I guess you perform the same when you're analyzing the likelihood of confusion? Yes, no? Well, if you notice any differences between the practice, please interrupt me and we can discuss, okay? So with these four factors, we take into account the overall assessment, and then we decide whether there is likelihood of confusion or not between the signs. So here, sorry, I invented one example of, for example, Miguel Odoru. We have class 32 beer, class 30 coffee, and another class of 32 beers of drinks. So I will continue using this example through the examination of an opposition. So first we will start with the comparison of the goods and services, and those are the canon criteria, the factors that we consider. Some of them are stronger factors. So then we check whether the nature of the goods and services is the same, the complementarity, the purpose, whether they are in competition or not. They can be substituted, the usual origin, the relevant public, the method of use, and the distribution channels. So one of the examples here, the comparison between beer and soft drinks. So they have the same purpose. They are drinks to be consumed as a drink beverage. They can be in competition, so the consumer can select between drinking beer or soft drinks. You can buy them in the same retails or supermarket. The relevant public is considered as well the same. The method of use of that kind of goods is also the same. However, they don't have the same nature. The beer may contain as well alcohol. Well, in this case, for the class 32, it is without alcohol, but they're not the same nature, not the same procedure. They are not complementary, not used at the same time. And normally, the companies who produce these products are not the same, not the usual origin. But if we do the global assessment of all those factors, we will encounter that there is a similarity. Okay, they are similar to an average degree. In the case of the comparison with the other type of goods that were contained in the contested in our example, then we see that they do not coincide in any of the factors that we take into account in the canon criteria. So then these goods will be dissimilar. Okay, I marked here in red. Oops, sorry. Then our opposition will continue only for those goods that have been found similar. In our case, some of them even identical, beer and beer and soft drinks similar. So we'll continue with the next section of the opposition decision. Just to give you as well as some information for the examiners that we perform the opposition, we normally check in our guidelines. So there is a specific chapter, not only how to compare and all those canon criteria, but also some specificities of some specific industries. Okay, in the pharmaceuticals, when the retailing of goods and services, whether the companies, you are comparing the services of retailing, are the two retailers, or the retailer of a specific good versus that specific goods, there might be some similarities as well there. Okay. And also another tool that we use is the similarity tool. It is part as well of the TMDN portal. The convergent practices are also stored there. And we include not only the information from EUIPO. If you see there, you can select the office, not only EUIPO, but other European member states that are part of the network. Also, they have the pair of, and for examiners from UIPO, this is compulsory. So we normally perform the search. So I will look for beer, coffee, and then I got the result of this similar. This helps a lot. Okay. Then that we have compared the goods and services, we move into the relevant public. For the relevant public, we distinguish between the general public, which is the public at large, and the professionals. So the business customers and the specialized public. I think during the discussion this morning, it was mentioned already that depending as well on the kind of products, the goods, the publics are different, and then the degree of attention as well has an impact on the possibilities of confusing the signs. So in case of expensive purchases, brand loyalty, or for tobacco or pharmaceuticals, the attention of the public will be higher, which means that it will be harder for the consumer to get confused. Okay, I'm imagining now a tobacco brand. Probably the person who is always buying the same brand of tobacco will not be confused when it has another product packaging. Or I have a little son, so I'm sure he will not confuse the trademarks of some of his toys. Okay. Well, then the average attention, it is for normal consumer goods, and then a lower attention for very inexpensive goods or purchased easily or daily, sorry. That can be, for example, the bread or the milk, things that are we normally, even by default, we encounter in the supermarket shelves. And once we decide which kind of public, the relevant public that we have in the comparison of our signs, then we assess the distinctiveness of the alien mark. So here is where acquired distinctiveness can be claimed. So we distinguish between the reputation, well-known, or acquired distinctiveness through the use of the mark. Here, in case it is proven that the trademark has an acquired distinctiveness, this means that the likelihood of confusion, it is higher. Yeah, sorry. Yeah, there we are. So, but one of the things that we have is that those degrees of having a higher degree of distinctiveness or being descriptive of generic, that means that one trademark is distinctive or it is not. We cannot say once it's registered, we have the Formula One case from the Court of Justice. Once a trademark is registered and is our earlier mark in the opposition, we take it as a trademark granted, and we cannot say, sorry, 1 hour left. We cannot say that it is devoid of distinctiveness. Okay, here in our office, most of the earlier marks are national marks. So imagine if me as an opposition examiner, I'm saying that the trademark in which the position is based is non-distinctive. I cannot say that. So at least has a minimum degree of distinctiveness. And depending on the relationship between the goods and services and the evidence submitted, it can have acquired distinctiveness or broader protection. So then, in my invented example, I will consider that the Miguel Doru has an average degree of distinctiveness for those goods of class 32 beer. One of the particularities from our examination as well in the comparison of signs is that the likelihood of confusion has to be in the whole territory of the European Union. And in the case of word marks, we have different languages spoken, so we should consider all languages. However, we can focus in one territory because we have some of the cases that if there is confusion in only one member state, this suffices to reject the trademark application. It is considered that there is a likelihood of confusion in the whole territory. So, yeah. Well, I hope you are following me. Okay. So then when we compare the signs, as we were mentioning before, we take into account the global comparison. So the weak or non-distinctive elements, and as well the dominance. And for us, the dominance means the visually outstanding. Okay, so even a generic or descriptive element, even if it is very, very big in the sign, it can be dominant for us. The comparison of the goods, as I said before, we compare it visually, orally, and as well conceptually. So you can imagine that for the 27 member states, the comparison for us is quite complicated because of the difference of the languages, the orally and conceptually, depending on the public that we are taking, it will be different. That's why when we are drafting oppositions, sometimes we use the case law for basing on only one country, one relevant public, and then we focus on that part of the public that might be more prone to confusion. During the overall assessment, we also take into account some of the decisions from the court, from the General Court and the Court of Justice, and especially we take into account the overall impression, taking into consideration the distinctive and dominant components. Through case law, also, we take into account that the average consumer only has the chance to make a direct comparison between the marks one. So it has to trust in the imperfect picture or the imperfect recollection. This really applies when, for example, there is only one letter misspelled between the signs. So it has to rely on the image, the imperfect recollection, the imperfect picture of that sign. And even consumers who pay a higher degree of attention, also they need to rely on that memory, on that imperfection collection. So as I said, the likelihood of confusion must be assessed globally, taking into account all the aspects that I mentioned before, the relevant public's perception, the dominance of and distinctiveness of the elements of the signs, the similarity between the goods and services, and also there is another concept of the counterbalance. So a higher degree of similarity of the goods and services may offset the less degree of similarity between the marks. As well, another aspect to consider during the oral assessment is that the category of the goods and services. We have some as well some cases from, for example, alcoholic drinks where the oral perspective has less impact than, for example, the visual or the conceptual, because normally the oral, the beverages are ordered orally. So because of the noise and the ambience of the restaurants or the pubs, the oral aspect has less importance. So here in our example, I will conclude probably a partial likelihood of confusion. Okay, it will be upheld for those goods that were considered identical or similar and rejected for coffee. So the contested trademark application will continue only for coffee. And here I included some examples. What do you think in this one? This one, it is important also to consider that it is for class 9 helmets and class 12 bicycles and parts and the territory of the European Union. Any thoughts on that? Very good, Gonzalo. Yes, because the coinciding term in between the two signs is the term force. Okay, so in taking into consideration the goods and services, especially the helmets, that it is one of the characteristics will be to be hard and to have stronger protection. Then the remaining elements, the letter X and the FSAK, will give sufficient differences between the signs as well. I didn't go into details, but also we take into account that the differing elements, one is the beginning of the signs, that is where the consumer also pays more attention when reading uh, a word mark. In this case, Aqualia versus Aqualogy in classes for water treatment services. What do you think? Water treatment, Aqualia, Aqualogy. No, exactly. Because of the same, okay? The coinciding term is aqua, even though they both are included at the beginning of both signs, but it is very, you can split it, no? So you can perceive it. Okay. Yeah. Gonzalo, you want to say? Okay, sorry. Well, and here I wanted that I will go very quick, maybe not to go in many details, but as an OPPO decision examiner, I will also wanted to share with you what we have in our office about the efficiency and the procedural economy, because um, in our case, the obligation, and it was determined by the General Court, we don't have the obligation to examine all the opposition and all the earlier rights and all the earlier grounds. So in one example, I received an opposition of a trademark application based on several grounds and several earlier rights. We don't go and analyze each of them. If we have, let's say, the winner, then we reject the trademark application and we do not enter into examining the rest. I don't know if you have that practice as well in your office. What do you do when you receive, for example, 3 earlier national trademarks? Or is this performing during your ex officio examination? So you just take into account the winner, right? Yeah, maybe May.
Um, in our practice, we list down all the conflicting marks. There is no, we don't have the discretion to choose which mark would have the widest, it's very different. So, because as you know, our position is post-registration.
Mm.
So it makes all the difference.
Yeah.
And actually, this practice in EUIPO I find very efficient, where you have the opposition pre-registration, because it will not go up to our sort of Board of Appeals, which is Bureau of Legal Affairs. So here in our end, in first instance, we list down all possible conflicting marks, and I would think that the examiner in this situation has that much discretion. Which one do we think is conflicting and which one is not?
Yeah. Okay, interesting to know. Because also sometimes when we have forum with our users, is one of the questions that always raised, because sometimes they file a lot of evidence for reputation or for acquired distinctiveness, but if the examiner has another earlier right with all that evidence, probably we'll go through that one because of reason of efficiency from the examiners and from the office perspective. Okay, so I think Yeah. Well, I had some examples of that efficiency during examination of the oppositions, but I think we can continue with the reputation and the well-known. I don't know if you have any other questions related to the relative grounds. No? Good. Okay. So then we move to the other presentation, please.